You're listening to the HR Mixtape, your podcast with the perfect mix of practical advice, thought-provoking interviews, and stories that just hit different so that work doesn't have to feel, well, like work. Now, your host, Shari Simpson.
Joining me today is Jim Reidy, employment lawyer, public speaker, writer, and artist. Jim, thank you so much for jumping on the podcast with me.
Oh, it's great to be here.
So we are talking all things legal, and I want to start with what's the most bizarre case you've handled in HR law?
I would say this. I've been practicing for 35 years. So to say the most bizarre, how long do we have?
Right, only 20 minutes.
Okay. So I thought of this quickly this morning. I thought of a couple of quick ones, and one would be an employee new to a company, and I think it was a bank, who said, I've got an environmental allergy. And so could you not have candles or things like that? Like they asked the staff and they said, would you mind suspending that?
Yeah.
And she said, how about no perfume or lotions? Begrudgingly, the staff said, okay. And they said, and she said, when people come to the counter, so would you mind? They said, all right, how about this? We'll put you on the teller window for the drive up. It's too cold. Okay, we're going to put you back on the window. All right, but if you put in the teller line, but if you put me back on the teller line, can you put a sign up at the lobby that says all customers can't wear deodorant, fragrance, or other lotions?
How'd that go over?
One of my clients once said when they fired someone, said, we encourage you to find your happiness elsewhere. So she left. She sued for disability discrimination. We prevailed and I think there was another one too where there was a bizarre case, and this was just funny and bizarre, but the employee claimed they fired an employee for sleeping on the job. I said, okay. And he sued for discrimination and said, I have narcolepsy.
Okay.
So could be accommodated. It's a seizure-like disorder. Turns out he didn't have narcolepsy, but that's not the funny part or the most bizarre part. The initial investigator said, narcolepsy. Ooh, he likes to have sex with dead people?
Oh, no.
And I guess to say,
oh, no.
No, that's necrophilia. That's something else. Let's go with narcolepsy, the seizure. Okay, proceed. Well, had to take a breath before you could proceed from there, but that was bizarre as well.
Yeah, I am sure everyone listening has their, we've talked about this before, their HR book that they're writing in their head of all the just wild things they've seen. So we all have encountered many different things in the HR space, which kind of leads me to think about the next question. You know, one of our jobs is obviously managing risk, legal compliance. If we don't have an internal, counsel that falls on us, and we partner with people like you, employment lawyers, to stay ahead of that. How do we marry that with creating great company culture? How do we make sure we're staying compliant, but also maybe we have a culture like Google or Netflix or Zappos or something like that that's pretty progressive and modern and new? You can do both, right? How do we do that?
Yeah, I think, well, first of all, compliance is compliance. I mean, it's understanding the rules and being compliant, following the rules. But the other part of it is creating that culture. I think the most important thing is, one, having a culture, two, proper messaging, and three, walking the walk. Because you can have these great posters and the great vibe, but if you don't walk the walk, it's not real. So I think people can pretty much see through that. I love this expression. Don't tell me what you know until I know that you care. So I think that's important. So I think messaging and truly walking the walk.
What are some of the biggest misconceptions you've seen around HR law that people think?
Well, the biggest misconception, I think, is that it doesn't apply to us, or the investigator they'll understand what we're doing. Investigators come in with a predisposition to enforcing the law. They're not a part of your company. They don't really care if you make a profit or not. They're just being prepared for the investigator who's not going to know who you are and understand where you're coming from and staying in compliance.
I think that's a really good point. we have talked before about different types of regulatory bodies that come into organizations like OSHA. That's a pretty common one, right? And how do you prepare for an OSHA investigation, and how do you make sure that you're compliant in all the things that you need to be compliant in? And there can be a lot of fear of that, but the reality is, if you are prepared, if you know the boxes that you need to check, then you can handle those kind of requests as they come in the door, and it won't be as dramatic. Have you encountered, I'm sure you've encountered, but has there been legal cases that you've worked that you have seen it completely transform an organization, the outcome of that case?
Yeah, it goes both ways.
Okay.
On the one hand, if things went really bad in a case, that it could be catastrophic, financially catastrophic and otherwise, or divisive within the company. It can go another way too, where it's like, all right, we had a good experience here, and we're better for it, and we can grow from it. And and think about the case of the bad acting supervisor or the bad acting CEO that was let go, and then ding dong, the witch is dead, and things get better.
Yeah.
But the transformation really truly depends upon the groundwork, like you said at the outset, preparing, following through. And when you're dealing with an investigator, be authentic, deal with them, get the job done, but also not be afraid to speak to the C-suite and speak truth to the C-suite. And that requires courage.
And that's a good point. If you are not involving your C-suite in or you're not making sure they're completing their required training, that's important. You need to make sure that, and you might even extend that out to your board if you have a board, right? You want to make sure that they're completing compliance training as well. How have you helped HR professionals stay on top of legal changes? I asked this question to our previous guest because there's, if you're in multiple states, let alone multiple countries, and you're trying to balance both state and federal guidance, what's your advice on how to wrap your head around it all?
It's a lot because, gone are the days where HR just worked in one town, one state. Now it's not only multi-states, but it might be global. So I think you tap into resources. I work with clients coast to coast. Even though I'm in New England, I work coast to coast with clients and sometimes internationally as well. So all the resources available, everything from SHRM, Paylocity has been a great resource, BLR, Thompson, there's so many. But I think the answer is you got to stay up to date. You got to pay attention, because the worst thing that can happen is there's a compliance audit and the C-suite says to you, wait a minute, why didn't you tell us about this New York law? Why didn't you tell us in California we couldn't do this or that? Now we're facing a pretty substantial civil penalty. Yeah.
How do you help HR deal with those legal risks when they come across them?
You get after it. I think what I do is I partner. I get into the foxhole with the client. I don't basically say you're on your own. It is your company. I'm here to advise you, but I give you practical advice. I understand the company. I understand the culture. I understand the problem, and I share the law. And then I help them navigate. I don't outline, you've got 3 options, best of luck. I'm out of here. I can't terminate the employee. I can't make certain decisions, but I can recommend, if this is the course you're going to take, this is what you're going to face. And I'm here to assist you. Yeah.
I am sure that you have clients that you've developed good relationships with, people in HR. I know that when I was in my practitioner role, I had an employment lawyer that I just absolutely adored and became good friends with. And there were plenty of times I would reach out to that person where, I knew we were making a bad choice. I wanted their direction and guidance to either affirm what I was saying or correct me. But I found myself in a situation where the leadership I was reporting to was like, yeah, we know we don't care. What is our role in HR in that? Is that our moment as an HR practitioner to say, okay, this company is no longer for me? Is it our role to get really passionate about the company and double down? What have you seen with the people that you're close with? I know that's a big question.
It is a big question, but and the answer is what we learned the first day of law school. It depends. It depends on the issue. It depends on your interest in salvaging the company and your relationship with the company. It depends on the stakes. If it's something like, this is really bad, and I might be personally liable, or my reputation could be at risk, then you might have to say I'm best to vote with my feet. But if it's, look, I can fix this, and it matters courage and fortitude, standing up and saying, look, let me be clear. And sometimes it says, can we bring in counsel to discuss with you? So that's what my job is to back up, support, and provide that information. So you're not in the wilderness, you're not alone.
What do you think is going to change when it comes to HR law? And I don't mean non-compete or overtime, because we know that that's out there right now. But as you think forward, what are some things that you're anticipating you're going to see?
I can sum it up in one word: change. It's constant change. You know, from being in the field.
Yeah.
You know, from being with Paylocity, it's constant change. Who would have thought 15 years ago, 43 states would have legalized marijuana? Who would have thought 2 years ago, we'd be talking about 2 states that have legalized therapeutic use of mushrooms? Who would have thought non-competes would be outlawed generally, and so on and so on. It changes all the time. Paid family leave. Just think of all the changes. So the future of HR is just change.
What advice do you have for smaller businesses who are navigating some of those complex HR laws?
I think tap into every resource you can. Chamber of Commerce. So if they're not big enough to have a dedicated employment lawyer, or but HR associations, the local HR associations, Chamber of Commerce, and so on, the business and industry associations provide great information. And I think that's the best for the small companies, and also just the network of HR professionals. Talk to someone more senior who's got some advice.
I have shared this before, but one of the resources that I really appreciate that SHRM has is they have for their members a multi-state law tool that you could basically go in and say, hey, I'm functioning in these 3 states, give me all the laws. I would not say use that as your end all be all, but it's definitely a good place to start to wrap your head around what's out there in the states that you are supporting. What are you seeing from a global perspective that you think is going to impact legislation either here in the States, or we're going to see more organizations adopt it because of how organizations are becoming more global?
Yeah, I think that what we're seeing is already influences from Western Europe. 4-day work week, reduced work hours. We saw that in France. We're seeing that now in the U.S. Massachusetts tried a tax program. Even in Little New Hampshire, there was a proposal for 4-day work week. There's one in Congress that Bernie Sanders recommended. Those are sort of European concepts. Garden leave is a European concept. And we're seeing that as a part of the end of, before non-competes ended and so on. So I think more and more you'll start to see some of those things, but there are still cultural disconnects too. You think about somebody coming from another country trying to understand our laws and our workplace issues. There is still some divide in that regard.
Well, it's, I worked for somebody many, many years ago, and the parent company was in the Netherlands, and our CHRO at the time was pregnant, and she was going out on maternity leave, and she was talking to one of the leaders who is located in the Netherlands, and he was like, oh, well, what are you going to do for your year off? She's like, my year off? What are you talking about? She's like, I'll be gone like 10 weeks. And he's like, what? He's like, how can you bond with your baby? I mean, it was such a surreal conversation for both of them, because they were like, it was their experience, and that it was hard wrapping their mind around what each other was experiencing. So I definitely hear that. Yeah.
But now we're seeing that influence here in the U.S. from California to Massachusetts. There are extended more. It's almost half a year or more of family leave.
Yeah.
And parental leave, which was never the case before.
Yeah.
So while there are still differences, we're getting more homogenized in that regard.
So California has always been a state to watch when it comes to employment law. What other states are kind of popping up that we should watch a little bit closer, maybe besides just California?
Certainly California is leading edge. Colorado, Oregon, Washington. Those are the ones. New York. I think those are the sort of leading edge. Massachusetts too.
Okay.
That you see more progressive.
That's good to know. I just think it's good to keep an eye on some of those things. As you think about flexible work, how do you see us being able to support that in a way where we don't put ourselves in trouble when it comes to things like compensation and different plans and fairness and all the things that I kind of foresee HR having to deal with when we talk about gig economy, flexibility, fractional workers, whether you're a contractor or not, right? We saw that kind of come up in this last year as well.
Yeah, I think flexibility is going to be the new normal. And, you think before COVID, 6% of the U.S. workforce worked remotely.
Yeah.
At the height of COVID, it was 65%. We're now about 30%, but there's a pushback going on right now. A lot of layoffs since last year, and they continue rolling layoffs and adjustments, expensive commercial real estate. And, you've got CEOs saying, I think that people that work remotely lack hustle. And if we have a rift, they're the first to go. Well, you're losing talent in that regard, too, in many regards. So I think being flexible means, having a company, again, it goes from top to the first employee, the company, the most recent employee. And it's job one is doing the job, whatever the job is. But how the job is done, that's evolving too. So being flexible, as long as the job gets done, that gets to reasonable accommodation, that gets to a whole bunch of other issues. But again, it's a leadership issue. It comes from the very top. They have to embrace it. Because HR, if you're left alone working with these accommodations and then the C-suite doesn't buy in, you're going to have a pretty serious disconnect.
Well, and we recently talked about reasonable accommodations. They are, I think, much broader than we have given them credit for. And maybe you could elaborate just on that a little bit, because I think it's a really fascinating concept that I don't know all HR people have heard.
So at the beginning of the ADA, which was 1990, effective 1992, the estimate was 1 in every 36 Americans could be considered to be disabled. When it was amended in 2009, 1 in every 4 to 6 could be considered to be disabled. So that's a disability. But then the second part of the analysis is the person a qualified individual with a disability, and could they perform all the essential functions with or without reasonable accommodation? What's a reasonable accommodation? It's reasonable till it's not. It's like, what does that mean? Well, that means that unless it represents an undue hardship or direct threat, undue hardship being cost and effect to the organization. That's tested all the time. So it really is, it gets to be the point where it's the burden is on the employer to show it's not reasonable, or it represents a direct threat to the employee or to someone else. And you never focus on cost, because if you say we can't afford that, then let's say really open the books and show me all the other things you spent money on. But it really is going to be that balancing act. It's job specific. It's individual specific, because not every back injury is the same. Not every carpal tunnel is the same. The most important thing to mention, though, is, because this is where HR gets caught up in it, is there such a thing as an indefinite accommodation? And generally speaking, the answer has been no, but that may be changing too.
Wow.
So it really gets to be, it's very specific, very unique, but it is ever changing. And like you said, it tends to broaden in time. But ultimately go back to common sense. Is the person performing the job as required?
Yeah, absolutely. Well, as we wrap our discussion, what is maybe one thing that you really wish all HR professionals would know or think about when it comes to HR law? I
would say this. Trust your gut. Because all too often the swirling notions of, wait a minute, I read this in the law, or I heard about that, or I'm concerned about this, and you get really confused, or you're just worrying about, I'm afraid of our CEO or our CFO and what he or she might say, and so on. It's like, trust your gut, because ultimately it really should go back to common sense. There are bizarre laws out there. There are bizarre interpretations of the law, but you can't go wrong when you trust your gut and treat people decently. I love it. Trust your gut. Treat people decently. Thank you so much for sitting down and chatting with me. My pleasure.
I hope you enjoyed today's episode. You can find show notes and links at thehrmixtape.com. Come back often, and please subscribe, rate, and review.